If you have a global business, you will have global IP dealings, you will have global litigation. So doing business globally really means that you have to have lawyers in the countries, in the jurisdictions where you may face problems or where you want to enforce your rights.
We have four primary areas where we handle patent litigation, for example, or IP disputes in general. And that's the United States, Europe, Asia, and Australia. And we have the ability, when we're representing clients, either as a plaintiff, when they're asserting a patent or asserting trade secrets or asserting trademarks, we can bring those actions in multiple jurisdictions at the same time. We could also defend them at the same time. We are built to be one team across the globe, across those major jurisdictions, to be the most efficient and effective that we can for our clients.
It's also done by making sure that your contracts relating to the development and commercialization of your IP protect your IP. So clients really have to look at all of those factors: patents, copyrights, trade secrets, trademarks, and the contracts themselves, to make sure that their IP assets are protected and that they can monetize it in a way that they intend to. And of course, IP litigation. We, as transactional lawyers, try to stay away from the IP litigators in that we try to create contracts that will not trigger litigation. So where we collaborate with the litigators is normally in the settlement context. And oftentimes those settlement discussions will involve a complicated ongoing relationship between these fighting parties. And we're there to kind of bring some practical, real-world experience to those settlement negotiations to make sure that not only is the litigation settled, but also that, there's a chance that these parties are going to have a successful long-term relationship going forward.
You want to make it work for both, right? It's not a litigation where you hammer in on one opponent. You want to cross the bridge. You want to find a solution which is acceptable to both parties. So you need to be able to place yourself in the other one's shoes and understand their needs as well. A licensee in Europe will have different needs than one in Japan, and vice versa, of course. There, our benefit is we will have represented European licensors or licensees and vice versa, so we can also explain to clients where the counterparty may be coming from, what's their concern. And we will know solutions how to address those concerns, which makes a deal happen.
We do have a real breadth of experience in the IP group. We have litigators who've litigated in all of the major jurisdictions in major cases for decades. We also have the patent lawyer group, which has that scientific background, and we just have the benefit of a wealth of different experience in that group. So there is always a group of people who will have exactly the sort of science background, whether it be PhD or even postdoc, who have exactly the right scientific credentials for a key matter.
Me, for example, I'm a graduated chemist and a litigator. And that essentially, it makes a difference in a court case because I understand what the experts are saying, and I also can understand how the judge may be thinking. And it's all building a bridge. It is bridging the two worlds in a way.
And what that for me means is that I have a group of colleagues that I can work with to meet client needs regardless of what those needs are and where those needs are, rather than being focused on any one particular jurisdiction.
And it enables us to make sure that the client is getting the most experienced lawyer on their matter, and also that there's effective and efficient communication between the team members around the globe, so that the client has just one firm to use, one firm to educate, one firm to work with, and they get seamless representation.
Employing a cross-border strategy means that you know what your colleagues are doing. You have to know what the jurisdiction may offer you, where are the advantages and disadvantages that could come in, and that you have to translate into a strategy. And this is what we do. We know how to litigate in various jurisdictions. We can pick and choose from these.